Thanks. Oh, great. That was so easy. Thank you for putting the slides up so quickly. And I just do right-click, right? Thank you. So I'm going to go over, I think I'm going to be a little bit more positive than maybe some people have been today, although I do like being on the last panel because I think the early morning and afternoon discussions were so rich, and they laid the groundwork really well for our discussion. And I apologize to Arnie Caliber because he's seen some of these pictures very recently, but part of the reason this slide is up here is just to echo what people have said earlier today, which is that many of the structures we're seeing today in what's called precarious work have been around for a long time, and in fact, many of our laws were enacted specifically to address the problems in subcontracted and precarious work. So we saw sweatshops at the turn of the 1900s, and they're not that different structurally and in terms of job quality from some of the modern jobs that we're talking about. And that's important for policy reasons. So some of the new iterations of subcontracted work, the way NELP thinks about subcontracted work and when we're talking about policy is subcontracting is just companies' decisions to contract with somebody for either with another company for the labor or with another person for the labor. So the independent contractor question is really just the company's decision to contract with an individual as opposed to decision to contract with a company. So the overview, and the way we look at policy options is you can either cover the worker as an employee or just cover the worker period, but it doesn't matter what label they're given. You can cover the company either as an employer or just cover the company and don't even bother giving it a label, or you can cover the job, the sector-specific things that we've been hearing about. So policy option one, cover the worker. And the good news is that a lot of this has been done, and Sharon mentioned some of the great work that the Department of Labor has been doing in the last 8 years, but really this has been done since the 1930s because the Fair Labor Standards Act for one, but virtually all labor and employment laws are intended to cover most workers and do cover most workers. We just kind of forget that sometimes. So the good news lately is that the Department of Labor has taken leadership on this and has collected existing and long-standing laws at the circuit level, at the Supreme Court level, and in some cases at the district court level that say most workers are employees. And again, this isn't new. It's not new policy. It's collecting all of the good existing case law that's been out there, and that's been out there for a long time, and under which companies have been operating for decades. So that's the other point that's important to make, is that the parade of horribles and the panic that the International Franchise Association, the Chamber of Commerce, and other employers are trying to feed out into the public rings hollow because they've been operating under these broad laws for decades. The NLRB has an independent contractor initiative that is relatively new, but again, it's just urging application of a long-standing existing statute, the National Labor Relations Act, that doesn't define covered employment quite as broadly as the Fair Labor Standards Act, but does define it much more broadly than we are led to believe. It's the right to control, it's not control in fact. Some of the things that Valerio was talking about using the control test more broadly shouldn't be radical, and if you look at the restatement and some of the recent National Labor Relations Board memos that Dick Griffin and others have put out, they're again just collecting existing and long-standing definitions and standards and reminding us, there's also, in fact, how broad it is. NELP materials, but states, more than 30 states already have laws that are called the ABC test that create a presumption of employee status. That are called the ABC test that create a presumption of employee status. So you're starting with a win if you're a worker and you want coverage, which again, these are mostly under state unemployment insurance laws, which again, we're running their own business. Pretty much everybody, unless they're really running their own business, and most of the low-wage workers that we think of that are misclassified as independent contractors aren't running their own business under anyone's definition. Couple more examples. workers who run their own business. That's what we're talking about when you're talking about employee versus independent contractor. And some of the Uber cases that have come out are asking these really good questions about, if you're an Uber driver and the price of gas goes up, can you pass it on to your customer? No, that's what a regular business would do. If costs go up, you pass it on. So there's lots of questions that are being raised by Uber and some of the newer cases that go to the core of whether or not the worker's running a business. And the right to control is just one consideration. These are some of the factors. They're in the slides in the materials, but there's a lot more than just right to control that we have to look at. And this is, again, under existing law. We don't need to change, and there's a lot we can do here. I'm going to skip over this part because I was just told I don't have that much time, but this is in the materials, but why we should care about whether or not workers are classified as independent businesses or not, and we've heard some of that this morning. Policy option 2 is cover the company. And this is also called joint employment. Again, labor and employment laws have had joint employment in their statutes since the beginning. It's nothing new. Don't believe the companies and the frantic messaging from the other side. All labor and employment statutes have the ability to cover more than one responsible employer. And so the NLRB has been leading on this with the Browning-Ferris, the McDonald's case. The Department of Labor, under David Weil, issued a guidance, again, just collecting existing laws and providing some context to those. OSHA has been using its joint employment standard to good effect to combat problems with deaths in the job. And California's is really the strongest. It doesn't even require a finding of employment. It just says if you're a company and you decide to contract out, that's fine, you can do that, but you're responsible along with your subcontractors for any wage and hour and workers' comp violations. So you don't have to find employer status. It's just if you decide to contract out, you're both responsible. We're testing this model in Massachusetts as well, and it's a great model because you take away all the fact-based confusion about who's an employer and who's not. So this is some of the things I mentioned already. The main thing to also remember about joint employment is that the only time you need it is if one of the employers isn't taking responsibility and can't fix the problem. So in the Browning-Ferris case, the temp agency wasn't able alone to deliver the recycling workers what they wanted. So they said, the workers said, we got to bring in Browning-Ferris then, because you both need to be around the table. If you have a low-road temp or staffing company putting workers in a warehouse and they're not paying the workers, and the low-road staffing company doesn't have the capital to pay, you have to bring in the worksite employer. That's the point behind joint employment, and that's why we need to continue to both enforce it but also to pass laws like California's that just creates automatic responsibility. Covering the job is kind of what we've heard a little bit around sector bargaining and sector-specific remedies, but it's basically if you see a job that's just so persistently crappy, there's no accountability, the wages are bad, it's dangerous, it's just cover it. So in construction in Pennsylvania, it doesn't matter who's employing you, whether or not you're called an independent contractor, how many levels of subs there are, everyone has to be covered by workers' comp on the job site, period. So something like that could be applied to a lot of other sectors. Other states have laws like that the building trades were very, they got those passed. You also have hot goods seizures and stop work orders that enable state agencies and the Department of Labor to just stop work on a work site, again, regardless of how many levels of subcontracting, regardless of what the labels of the workers are on that job. If there's something bad happening with respect to compliance, you can just stop the work until it's fixed. And that quickly gets those in power coming in to fix the problem because they want the work to continue. So Sharon's already gone over the federal initiatives. They're not all going to go away. The new administration can take away some of this guidance, some things, but they can't take away the statutes that have been on the books since the 1930s and the good enforcement at the private level and at the agency level that should and could still happen. Part of what NELP is doing is organizing the private bar to step up again, because they do a lot of enforcement, at least on labor standards, and they have the resources and the interest, and even for very low wage workforces, they can and will make a difference. And then I'm just going to go quickly on this because it's relevant to policy discussions. NELP contracted with Hart Research to do message development and polling around non-standard and precarious work, and the results were really heartening. Even though it's hard to talk about what it means to be in these jobs, and we've even had discussions today about how do you define this work and what kinds of jobs, the public gets it, and there's a lot of support among voters. And we did these focus groups in North Carolina, in Silicon Valley, in Pennsylvania. So we did it in really different parts of the country, and the results were consistent across the board. So over 70 and sometimes almost 80% think that contracting out doesn't mean you aren't contracting out your responsibility. Lower wages is the top reason why people think contracting out and subbing out more and more, either to companies or other workers, is a problem. So also the notion is that it's not necessarily bad to have subcontracted or precarious structures. We've heard that this morning, but it's really when the companies are calling the shots and the workers don't have any power, that's the problem, and when the conditions are bad. So this is a big thing that resonated with the focus groups, and I think when we're making our policy arguments, we need to focus on this point too. And this is, again, a similar point, that it's not that all subcontracting is bad. It's just when it's done to evade responsibilities and results in poor working conditions and lack of worker power. So this is just more information, and this is in the materials. But again, independent contractor flexibility is posited a lot by the opponents, and so digging into that a little bit and what that means, and the fact that employment doesn't necessarily mean a lack of flexibility, does resonate with workers. A lot of workers have flexible jobs, but they're still employees. And permatemp and temp is a problem. People see that as a problem if those gatekeeping agencies are rushing to the low road and they're not providing, that they are fomenting discrimination, as Valerio mentioned, and if they're not really leading to permanent full-time jobs. Okay, I think that's it. Thanks.